Oregon Law Commission probate modifiers. That's us. We have two items on the agenda today. One is the walkthrough of the revised draft of the remote attestation legislative concept. And once we get through that, we'll dive into electronic wills. Sandy sent out the documents in your, it was email, what, days, a couple days ago, Sandy? It was the latest draft.
It was actually yesterday afternoon, about 2:30 or 3. Yeah.
The latest drafts of both. So those should be what you're looking at. Yeah, I see draft 422. So these came out yesterday. Those should be what you're looking at, and that's what we'll look at for our conversation today. Lori, do you want to make any introductory comments before we go through the remote attestation, just kind of what you've done?
Yeah, sure. So what I've done here is, this is quite a bit different than the draft that you saw last week. So we've pretty much gone away from the Kentucky proposed language, and we're working on this from the standpoint of trying to integrate it with how witnessing is discussed in Oregon statutes. And so that's really talking about when is somebody in the presence of somebody else. So everything that's in here is dealing with that issue. So it focuses on what electronic presence is and what the requirements are for being in somebody's, what it is that you have to do to be in somebody's electronic presence for the purpose of remote attestation. So.
All right. Well, yeah, and again, thanks for the work on the draft. I think it captured our inclinations from the last meeting very well. Let's start with, we have the section 1, electronic presence, and that is, now that's a definition based on the Electronic Wills Act. Different is highlighted in red. Who wants to explain that?
This is Lori Ann. So that was an error on my part. Different had been left out of the prior draft.
Oh, okay. Okay, so that's just a track change. Okay.
Right.
All right. Any comments on the electronic presence definition?
I just have a question, Lane. It's Jennifer.
Jennifer.
Would this be adopted by order of the governor, or is this a statute?
Well, I think what we're looking at right now is basically language, leaving the method of adoption open. I think based on our conversation last week, it more likely would be by legislative adoption, given at least questions as to the governor's, the scope of the governor's authority under an emergency order. Why?
Well, I just wanted to make sure that, you know, I understood that. And at one point we were talking about this kind of thing sunsetting. So then this, if this were legislative action, this would be permanent?
Well, I think we could, that's a discussion you have to have, I think, when we get to the end, whether to make this permanent or whether to make it just for the duration of an emergency. And I think there's a good argument to make this permanent.
This is Lori Ann. So yeah. Just as it's currently drafted, if you look at section 2, that's the sunset. So as currently drafted, it's intended to be dropped into one of the LCs that's on the agenda for if there ends up being a special session. And this is the sunset clause that's in that bill for a lot of the provisions that are in that bill. So it would sunset 2 weeks after the governor's emergency declaration expires.
I have a question.
Yeah, Eric.
I'm sorry, this is Eric. If I remember correctly from our last meeting, there was a question with regards to if someone who might be visually or hearing impaired, or who might not have the technology to have both visual and or audio.
Yeah, that was Chris's comment, I think.
Do we need to address that in this statement?
Eric, this is Gretchen. That's an excellent point. I don't remember that discussion, but I do think it's something that we should definitely be considering. I do represent the Commission for the Blind. Most of those folks do have the ability to have, you know, it's a different kind of technology that reads things to them so that they can hear it. But that I don't know I assume that there's, reading for folks who are deaf, and then recognizing that probably should be something we take a look at here. I'm just not quite sure how to word it.
I guess question is, do we need that should that be in the statute? Would it work in a comment? Would a word like adaptive be appropriate? I'm not sure what the language is for something like that.
So the use of audio and visual is 100% redundant in the sentence structure we have, because it's in different locations communicating in real time to the same extent as if the individuals were physically present in the same location.
Okay, that's a good point.
So if a hearing seeing person is in the same location as another hearing seeing person, we have audio and visual communication. If a deaf person who has no audio communication is communicating purely via video, they're getting the same communication in most cases that they would otherwise.
Okay, that's a good point.
So I
Chris,
think
let me ask-
real time covers it without
Okay.
adding the layers of potential problems.
Well, that's a good point. Maybe we can fix it by removing words instead of adding. Chris, are you sitting in a disco? Where are you?
I am sitting on a spaceship because my office sucks.
I love it. You're on the bridge. Okay. Lorianne, what do you think about that? And Susan, let me ask you too, as being the reporter of the eWills Act. How do you feel about just losing both audio and visual from this draft? So it just reads communicating by electronic means in real time. Oh, Susan, you're muted.
So this is Lorianne, and I actually am a proponent for not having that clause in that subsection A. If we remove that from subsection A, that way it tracks with the eWills bill for the definition of electronic presence. If the intention is to have this audio and visual requirement, I would suggest putting that down in subsection 2 that talks about the elements that are necessary for being in the presence of a person. But I do think that the point is well taken, that is already covered in communicating in real time to the same extent as da-da-da-da.
Susan?
And that's why when we drafted the eWills Act, we had this same conversation. There are various kinds of adaptive technologies. And we concluded that, as Matt just said, the language covers everything. And our concern with putting something more specific in was that those technologies will change over time, and we can't capture everything.
All right, then it's gone. It will read communicating by electronic means in real time, etc.
Lane?
Yeah, who's that? Mark.
This is Mark. I'm concerned that if we lose it entirely, that creates a bit of lack of clarity. I agree with Lorianne that I think it needs to be in section 2.
Okay. Let's save it for section 2 and see how it works down there. Again, without excluding people with that may be sight or hearing impaired. We have a definition of law. Everybody okay with that? And witness is a subscribing witness, and I meant to bring that with me and I didn't. Lorianne, the definition of witness in 40030.
Yeah, let me pull that up.
Lane, it's John. By the way, it's 42.
Oh, John, can you get a little closer to your mic? I can barely hear you.
Statute is 42030.
Oh.
Thank you, John.
Yeah.
My pleasure.
John, you
I have it up too, but Lorianne, you can go.
just a second. Let me hear from Lorianne first.
Okay, so subscribing witness.
John, wait. Go ahead, Lorianne.
Subscribing witness under 42030 is a subscribing witness is one who sees a writing executed or hears it acknowledged, and at the request of the party thereupon signs one's name as a witness. And this statute does apply to the execution of wills, just to point that one out.
Oh, thank you. Sandy put it up in the chat.
There you go.
Statute is there. Interesting, that sort of incorporates the hearing and seeing element back into this, but I'm not sure I want to try and fix chapter 42 while we're at it. So I don't know that I want to worry that issue in this definition. John, what do you have?
Well, I think this definition of witness is unnecessary. The stats 42030 is not being repealed. It's still going to apply. I don't know why, the will statute doesn't define witness.
Right.
Everybody just allows 42030 to define it, I suppose. I've never read that. But I don't think we need to define that term. It's already defined in the other statute.
Yeah, okay. Lorianne, do you think we need a definition of witness?
I like having the definition in here for a couple of reasons. First, this is a temporary provision, so it'll go away eventually. But also it flags that this is intended to apply to any time that a subscribing witness is required, because we're not dropping this into the chapter 42. So it's not going to be tied to the writing statute. So this way it flags it that this is intended to apply to those statutes.
John's point that we don't define witness in the wills statutes.
I don't think that we want to make this statute apply to something that 42030 doesn't apply to right now. That's way above our charge. So
John, what would those?
That just.
Yeah,
well, I don't know.
Yeah.
If you, I think the statute 42030 defines a witness. There are, you found a long list of situations in the statutes where witnessing is referenced. I think all of those probably already relate back to the 42030 definition. So it's just superfluous to create this statement here. And we don't have it in 112. So it's not needed. You don't need a definition of witness in the statute that governs a written will.
Yeah, that's section 42030. Is that are those definitions for the purpose of chapter 42, or are they broader than that?
They are broader than that.
Okay.
So if you look at cases that interpret 42030, that applies to advanced directive witnesses. Okay. It applies to witnesses to wills. It applies to a number of documents.
So if we take out the definition of witness, it still will functionally apply, right?
Probably.
What's the pleasure of the group? I'm happy to take it out. If 42030 is going to apply because it covers witnesses in all circumstances, then I'm not sure that we need to specifically incorporate it.
I think we should take, and I wasn't at the last meeting, but I don't understand why there's a requirement that the witness be in the state. That isn't a requirement.
Oh, we'll get to that.
So
yeah, we'll get to that. Lorianne, let's try taking it out unless it really becomes an LC issue. Okay. My inclination would be to take it out. We'll slim this down a little bit anyway. Okay, let's go on to sub 2. Witnesses in the presence for the purpose of witnessing, execution or acknowledgement of writing if the witness is physically present in this state. Okay, let's have that conversation. Why does the witness have to be in this state?
Lane, this is Brooks.
Yeah, Brooks.
One reason that we may want to retain that is the whole purpose of witnesses is we can bring them into court to say, you betcha, that is what happened. I was there on the day at the time. If we have witnesses in other states, we can't force them into an Oregon court where we're litigating the validity of an Oregon document.
Okay. There's the trial, there's the litigator's perspective.
So Brooks, this is Eric. If let's say you had an older will and the witness moved out of state, by them being a witness to an Oregon will, does that give you grounds to pull them in?
No, what we'd have to do in that circumstance is we open a case in whatever state they live in, obtain a commission from Oregon, register it in the case in Michigan, wherever, and then take a perpetuation deposition there. In pre-COVID days, that would involve, flying the trial lawyer out there to lay eyes on them and take the depo. But if we do all of that and we do it correctly, that deposition becomes directly admissible in Oregon court as if the person was there live.
So wouldn't that apply here as well?
Yeah, we could do that. I'm just saying it's a very cumbersome process. And even with Zoom and everything else, it adds a number of thousands of dollars to the client's bill just to secure the testimony of a witness that normally I could get with a subpoena. And, do we really want to allow that by taking out in this state?
Who wants
to? Well,
if you had a law firm, say in Vancouver, for example, who's licensed in both states, are we putting an undue burden on that attorney being able to be a witness to an Oregon estate plan by having that provision?
Yeah.
Well, there's no requirement currently that someone sign an Oregon will in Oregon just because someday a will might be litigated and it might be difficult to get a witness. This is, I think, creating a huge burden on both the client and the attorneys and the witnesses, just because someday something might be litigated. It's not like it's impossible, and it's a problem that currently exists with witnesses who are out of state.
And it occurs to me that you're likely to have a lot more documents witnessed than get litigated. So that
Exactly.
To impose this as a requirement on all witnessing, witnessing of all documents for the convenience of prospective litigation, I'm not sure that the burden justifies the benefit of doing that. Anybody else? I'm inclined to take it out.
Lane, if we take it out, and I think there are good reasons to do that, we might want to think about requiring the witness to be in the United States. This was something we talked about with electronic wills, but if a witness can participate electronically, they could be in, I think we used to say in the electronic wills meeting was Belarus, I don't know why we chose Belarus, but somebody could be very far away. And it's more of an issue with the electronic wills statute because of the concern that companies will be set up in Belarus to facilitate electronic wills. But it might apply here as well, although maybe if this does end up being a short-term provision with the sunset, maybe that's more than we need to worry about.
Let's think of the longer term as we're going through this. I don't see any reason not to. And maybe then, Susan, that's a good compromise. So Brooks knows at least he can, if he needs to get a witness, he can do it through some state-to-state relation as opposed to having to go to Belarus to try and find that person. Would the group be comfortable with that the witness be present within the territory of the United States?
And Lane, this is Brooks. It would be a great solution to this issue because getting admissible testimony out of other countries is a complete nightmare.
All right. Then let's, Lorianne, if we've got some standard language that refers to the territory of the United States, let's plug that in there. Okay. B, the witness is in the electronic presence of the person when, and now we have this one subdivided, the person executes or acknowledges the writing. B, at the request of the person, the witness attests to the person's execution or acknowledgement of the writing. C, the person signing the writing completes a declaration of electronic presence under penalty of perjury as described in ORCP 1E, and the witness completes a declaration of remote attestation Okay, let's go through those comments. Anything? Is this where we wanted to start? Who was it suggested bringing back in audio and visual? What was someone thinking of doing it in this section, and where and why?
Well, that was, Lane, this is Mark.
Yeah.
I was coming off Lori Ann's suggestion that the audio and visual clause be put down in section 2.
Okay.
If that's the stylistic issue for LC, that's great, but I think it does. I don't know if it's section 2 here or section 2 of the draft.
Well, see.
Oh, so this is Lorianne. It would be this subsection 2, subsection 2 of section 1.
Right.
And so it would be, these are the elements that are required for a witness to be in the presence of a person for the electronic presence purpose. So it would be in here. So just as the witness has to be physically present in the territories of the US, then we would say that the parties have to be in, and this is where it gets into how do you want to describe the audio and visual means, electronic means.
Well, but if we've taken that out, we say in the electronic presence, and there I guess we rely on just the broad language in real time to the same extent as if the individuals were physically present in the same location. Mm-hmm. What does the group think? Is that adequate, even in 2, sub 2? I'm not hearing this. My sense is probably to leave it without reinstating the audio and visual, because if we do that, then we have to somehow accommodation again down here, and I think we've eliminated the need to do that in the definition of electronic presence. And Susan, maybe this is something you could just kind of address in a comment, that for those persons who are sighted and who have sight and hearing, this means audio and visual. For others, it means whatever adaptive means is equivalent.
Well, Lane, let me, this is Mark again. Let me ask then, could we have a will by email? That's electronic, quote, real time if you're, or by chat, if you've got boxes going back and forth. That's electronic presence.
Well, I don't think it is, because
this is Susan. I think email would not be real time because there is a lag between sending things back and forth. So I can address that in the comment as well.
Yeah, that would be worth I think a comment to get into the details of that. But that's a good point. I think it does would merit a comment.
And even if you want to go to chat, which is arguably in real time, text, unless we're in a very, very strange circumstance, is not communication that is that is to the same extent as if you are physically present with someone.
Yeah.
And it's the same extent language that covers whatever audio, visual, spiritual, ecumenical issue you want to raise.
Yeah.
And I appreciate that. And I think that does merit a comment.
I do too. Yeah.
Explaining chat also what the group's conclusion was.
Yeah, I think this is good. And precisely why I think it belongs more in a comment than in the black law, because there'd be a lot of words expended in defining that, but a comment with a few examples of what we do not consider to be real time, such as chat and email, would really cabin this whole concept of electronic presence. Lorianne, do you want in?
I think that this is a policy decision on how specific you want to get with what it is. So if the group is okay with leaving it with the definition of electronic presence, LC has no issue with that.
Okay. thanks. Then let's, okay.
Lane, I think Ken Sherman, yeah.
Yeah, Ken.
I have a concern that the way subsection 2 of section 1 is structured now, it does not cover the situation where the witness is actually in the physical presence of the person signing.
Yeah, this is Lori Ann.
Already
So,
covered by the standard presence definition.
Yeah, isn't that already, yeah.
Right.
Go ahead, Lori Ann.
I did discuss that with one of the other LC attorneys who I consulted with on this draft, and her opinion was, as Christopher was getting at, is that that's already addressed by the regular definition of what presence is. So this is just expanding upon that in this specific situation.
But it says, I mean, it creates an exclusive definition for this section of what is being in presence of a person. And it doesn't say anything about actually being in their physical presence. I think that's at least confusing.
So would your concerns be allayed if we had either they are in the physical presence of a person or then these things? Okay.
Yes, I think
we can
so.
do that.
Okay, that's a good point.
Or would it make more sense to just have a reference of, in addition to in addition to presence as defined in other statute rule, or as defined in other laws, since we've got a nice definition for that there.
And I think we're
also in the.
Just a second, John. Let Chris finish. Chris, you done?
Yeah, that was the.
Okay, John.
I think we're confusing this. I think the 112, 235 applies to the document. I don't see why we want to confuse it and kind of try to make this provision cover the execution of the will in its totality. All this is doing is filling in one little gap with physical versus electronic presence for whatever witness is not physically present. So the one in the room signs the will, and that's a proper witnessing under 112.235 all by itself. The one that's in Peoria works electronically.
Both in the state or out of state, since we have a Peoria, Oregon.
I think if you add physical presence here, you're kind of confusing everything.
No, I agree. I think what we're talking about here is language that makes it clear that this is in addition to or different from other witnessing, in the physical presence. And Lorianne,
okay.
So
yeah, I yeah. So I see what Ken was saying. Sub 2 defines presence. Period. It doesn't say. Yeah, I think it should be. Shall be considered in the presence.
Yeah. So this is an additive definition to all of our other concepts of presence.
Right.
Yeah, I think Ken was on a good point.
Yeah. So Lorianne, do you know how you would do that? You don't need that.
There are two options. There are two options that I can see. One would be to do what I just suggested, which is just dropping in either you're in the physical presence of somebody or there's this other method.
Yeah.
Or down in subsection 5. So 5B, we say notwithstanding paragraph A of the subsection, this section doesn't apply to. And this is where I had initially, in the first version of this, I had a provision in here that said that it doesn't apply if the two parties are in the physical presence of each other. So those are the two options. I don't know if the group has a preference.
Whichever one do you think would be clearer? Would that maybe clearer to put it up in 2?
Yeah, I would prefer that.
Okay, good catch. So we will make clear that this definition is additive to all other concepts of presence for all other purposes. So again, we got physically present in the territory of the United States, in the electronic presence when the person executes or acknowledges the writing. B, at the request of the person, the witness attests to the person's execution or acknowledgement. C, the person signing the writing completes a declaration. And D, the witness completes a declaration. What else in this section? Anything? And Judge Donahue, I think you were the one who was interested last week in making sure that we had some sort of declaration that, that supported, the electronic witnessing of this. We'll get to the declarations themselves, but does this get close to what you were hoping for?
Before the meeting, and I think that would work, because again, what I was just looking at it from the standpoint of, if it comes to a court, what is the court going to have in front of it in order to minimize the need for any extrinsic information to be pulled in about the circumstances of the attestation, given that it's being done electronically. And I think this would cover that.
Okay, good. Anybody else with anything on subsection 2?
If I have a question, and this is a drafting question, and it seems that I'm the only one maybe who has this concern, but the way it reads to me, let's see, 1A defines electronic presence, and it feels like then 2 is also defining electronic, or 2, where am I? Yeah, 2 is also defining electronic presence when it says to be the witnesses in the electronic presence of the person when. It feels like there are 2 definitions of electronic presence, and maybe that's fine. Nobody else seems to be puzzled by that, and it's really more of a Lori-Ann question.
Yeah, I see B as being sort of a temporal application of the definition of electronic presence. Electronic presence is what it is, but you have to have these temporal elements. They have to be physically present in the state, in the electronic presence, of course, and then, yeah, then these other things that really are more about the circumstances of the witnessing, then being a further definition of electronic presence. Anybody else?
Yes, John.
That's right.
I had the same thought, but I looked at it more closely, and A defines electronic presence. 2 defines presence for purposes of 112.235.
Yeah,
and,
right. Okay, good point. Yeah.
They're actually 2 presences.
Yeah.
And if you think look at it that way,
for any other purpose.
Yeah.
So this is Lori-Ann. So the way that, so sorry, I'm doing track changes and my numbering just changed to a little b or 2b. Anyway, the witness is in the electronic presence of the person when these things happen. So it's 2 different things that are happening there. It's not an additional definition of electronic presence. It's saying the witnesses have to be in the electronic presence of each other, and then these things are happening while they're in the electronic presence. So it's not another definition of presence. It's so Susan, would your concerns be addressed if we changed it to something similar to the witnesses in the electronic presence of the person at the time that these things happen? I kind of struggled with this drafting wise, because I wanted to make it clear that they needed to actually be in the electronic presence when the person executed it, and when the person, the witness attested to it, and when the person signing it completed the declaration, and when the person witnessing it completed the declaration.
You know, Lori-Ann, I think maybe at the time is an even clearer statement of sort of the temporal sense of what follows.
That would help me, because it wasn't clear to me whether whether big C and big D, the declaration had to be done at the same time. So it sounds like the intent is that all this happens while everybody's in everybody's electronic presence. And I was having trouble getting there.
Well, I'm still having trouble with it, John. The 2 starts out by talking about being in the presence for witnessing the execution, acknowledgement of it. And then when you skip down to sub C and sub D, those things don't happen until after the will has been witnessed. So how can you, you're requiring a future act to occur in order to be in the presence when you actually witness the will.
Okay, that's, maybe C and D don't need to occur while the parties are in the electronic presence of each other. What's the
Well,
thought about that?
I think the way Lorianne said it last made a lot of sense. That's not exactly the way it's written, though. You know, it's part. You know, definition of presence is fine and dandy, but I think you need a requirement that an affirmative requirement that when C and D happen, there has to be presence.
You think they do have to be in C and D?
Well, I think you have to. You want presence. You want there to be presence when those things happen.
Okay.
But you don't.
I think if that's the case, at the time is probably the clearer statement of that.
Yeah, I don't think you want those.
Judge Johnny, I just have a.
Who's that?
Judge Donahue.
Yeah, go ahead, Judge. Oh.
It sounds like what the whole subsection 2 is doing is kind of successfully as a document, because that seems like the whole process for doing it. So would maybe change that first sentence into a witness.
Judge, you're breaking up. Sorry. Go back to, you said changing the sentence in 2. No, we're not getting it.
Okay. All right, my microphone. Let me try and call in and see if I'm a little clear.
Actually, right now you're perfect. Go for it.
Okay, so it sounded like sub 2 is actually, if you look at all the requirements, it looks like it's kind of describing when a witness or when a document has been successfully electronically witnessed.
Right.
So maybe if we change that first sentence in sub 2 to a person witnesses an electronic document, a person electronically witnesses a document when, and then lay out all those criteria, because it sounds like that's more what.
No, we just lost you. Well, yeah, Judge, why don't you go ahead and see if you can call back in or something there, because you broke up again. Let me go to Lorianne.
Yeah, so the reason that it is written the way that it is because all of the statutes that talk about the need for a witness talk about the witness having to be in the presence of the person doing the signing.
Okay.
And so this is written in a way that tracks that requirement. And so it's addressing what that presence is.
Okay.
And I think that is necessary to achieve the goal of this group.
Okay. I'm fine with that, but are we agreeable, everybody, that in sub 2B, we change when to at the time? Okay, I think that's a good suggestion. All right, then I think that takes us down to sub 3.
Before we delay this, John.
Oh, John.
I think we can actually delete C and D. Perhaps, because if you look at 112.235, in 135, 1A, it says that in the presence of each of the witnesses, the testator shall sign the will, direct the witness to sign the name or acknowledge the signatures, and then it's sort of, that's where the presence requirement.
Yeah, but the reason I think we would want to leave it in, number one, this isn't inconsistent with that, and number two, this will extend to documents besides wills. So chapter 112 isn't going to govern everything that this governs. So I think we want to independently incorporate that same requirement. So it may be redundant as to wills, but it's not as to other instruments.
This is Jennifer, and I agree that we should include those last two, C and D, and it might make it a little bit clearer if you were to say the addition of at the time, you could say at the time the following occur, and then that would make it clear that as part of this whole process, those declarations have to be signed. And then that would also kind of you know, make sure that maybe a lawyer or somebody smart is following the statute carefully and not just trying to do things online and being messy about it.
Well, Lorianne, I'll let you take that as a style suggestion.
Yep.
And yeah, I think we're in agreement then on sub 2. Who does somebody want to speak?
Yeah, this is Gretchen, and I think Matt had asked in 2 little b, large b, it says at the request of the person.
Yeah.
And so why is that language in there? Why, I mean, I think he said that it's redundant. We're assuming that witness has requested it. So why is that in there? And then I guess I'm not sure the purpose of that language. I don't see it in other statutes saying at the request of the person.
Well, actually, in the wills, isn't it in the 112? Isn't it at the request?
I didn't see it in. I did not see it there. It just says that they will sign in the presence. It shall be in writing and shall be executed in accordance with the following formalities. And
okay. And Lorianne, I see we have a capital T on the. So was at the request of the person sort of a late addition?
I'm not sure where that came from. I think that might have been something in combining the different documents that just ended up in there. The at the request of the person comes from, again, the definition of a subscribing witness.
Okay.
So
maybe we don't need it.
Yeah.
This is Matt. I joined a little bit late. Didn't know if you guys had already discussed that, so I didn't chime in yet. But my point was also that the at the request of the person language is in the declaration that we are asking the principal to sign.
Right.
He or she says, I have requested that so-and-so become an attesting witness. And so it seemed duplicative and also seemed a little confusing to add it there in that sub B.
All right. I think that's a good point, Gretchen and Matt, and especially if at the request is in chapter 42 already and in the declaration, we probably don't need it. So the A, B, C, and D just address events, and you're right, B is the only one that actually incorporates something, you know, outside of the event itself and at the request. Lorianne?
Yeah, I think that works. I'm fine to make that change. I had one more thing to comment on C and D there. Is I think I can't find in my notes where I pulled in the requirement for the declaration to be pursuant to ORCP 1E, and some of the comments that have come up seem to indicate that maybe you don't want to tie it to 1E. So I think having the group have that discussion about whether you want it to be that formal or not.
Thanks, and I'm good to raise that too. I'm happy to take it out and let this be complete in itself in terms of what it describes. Does anybody want to argue for retaining ORCP 1E? All right, it's out.
So how would you want to phrase that then? So the person signing the writing completes a declaration of electronic presence under penalty of perjury?
As described in 3A or something like that?
But you do want to keep the penalty of perjury language?
I think we do. That, to me, that probably helps, to some degree, helps protect this from fraudulent use.
Okay.
Everybody okay with that?
And then to that same point, I think Lane had a concern about in the declaration form, it had the for use as evidence in court. So if we bifurcate.
Let's get to that, Lorianne. Or does that relate to 1E?
It does relate to 1E.
Okay, then go ahead.
Because that language that Lane was commenting on is the language from ORCP 1E. So if we bifurcate this requirement from the rules of civil procedure, then we can take out that for use of evidence in the court language.
Excellent. I like that. So C and D will refer to sub 3, not to ORCP1E. Good.
Lane, just one second. Matthew Schrumpf asked me to, he wasn't able to share anything physically, so I actually just emailed everyone an edit that he had made.
Oh, wait, Matt's not on the call?
He is, but he wanted to share something in writing, so I just want to let everyone know I did email that to everybody.
Sorry, this is Matt. I'm only on the phone, not in Zoom, so I understand that Zoom has a way to post written comments. So I can't do that, so I sent this to Sandy just now. Going back to the discussion about relationship of the little b and what is occurring at the time that the witness is in the electronic presence, and John's comments about the declarations being something that seemed to occur after that, it seemed to me that what's happening, the when or the at the time, it seems to me that that the relevant act is that they're in the electronic presence at the time that the principal is executing or acknowledging the writing. And the sub capital B, capital C, and capital D seemed to me to be requirements for kind of how Judge Donahue was describing it, to be a successful witnessing. And it seemed like if we combined sub little b with sub capital A into a single sentence, the witness is in the electronic presence of the person at the time the person executes or acknowledges the writing, then the following capital B, C, and D could be changed to lowercase c, d, and e, and they would not be something that's purportedly needing to happen in the electronic presence.
Okay, so you really raised a policy question, and that is, we talked about it, but nobody seemed to jump at it, whether we want those things to occur at the same, all at the same time. Or is it okay if these, well, let's see. It seems to me we want A and B to occur together.
What do we mean by capital B? What is the act of the witness attesting? Isn't that the fact of being in the electronic presence at the time that the person executes their writing? Doesn't that constitute the attestation?
I guess I contemplate, at least as I read this and as I understood it, I see two things. One is the witnessing, and the other is the separate electronic presence. So let's talk about an advance directive, for instance, which you can do with two witnesses if you don't have a notary. So the witnesses would each sign the witness statement in the statutory advance directive form. And that would occur at the time the person executes the advance directive. So that accomplishes the witnessing of the advance directive. And then they would separately, in that case, sign this declaration that would really, that basically explains the circumstances of the witnessing. That's how I see two different things there.
So this is Lorianne, and I intentionally did not get into the details about how the attestation occurs, because I wanted to leave it flexible for each individual, each of the things that this might apply to. So it would be however a will is supposed to be attested would be, and that's by signing the witness's name to the attestation. For the advance directive, it would be how it's required in the advance directive statutes for the witness to attest to the signature.
Hey, Lane, can I check in?
I actually have some go ahead, John.
John?
I think it might be helpful to pattern these declarations more after the self-proving affidavit. It's a standalone. These are both standalone documents, just like the self-proving affidavit is. They don't have to be signed at the same time. The self-proving affidavit simply references that they witnessed the testator's will. And that's a good enough connection already. Here we've got in the remote attestation, I'm having trouble with this idea of the document to which this declaration is attached and of which it is a part. I don't know.
Well, John, let me put two scenarios there. One is, let's say a lawyer's drafted a will, which could incorporate the witnessing and this remote declaration in one document, or you've got the statutory advance directive that doesn't have this declaration built into it. You would have to attach that to the advance directive. So in that case, you would have the witnessing on the advance directive form in order to satisfy that. And then you would have this separate declaration that would have to be attached. And I guess Lori's point is she didn't get into all the specifics of that because it's going to vary from document to document and circumstance to circumstance.
Yeah, but who's attaching it to the document? When is it being attached? How do you establish that? It's just kind of vague. I think if you just reference the document, just like we do with the self-proving affidavit, that should be good enough. Because you're going to have counterparts executed to begin with, you know. So the witness's signature is going to be on a different copy of the document than the testator's signature.
But what the declaration says, at least, is it's the same document.
Yeah.
But let's get back to the question. Let's get back to the question, though, that Matt has raised, really. And let me frame it as: I think we want the witnessing itself to occur simultaneously with the person who is signing or acknowledging the writing. So I think A and B have to occur at the same time. But can we take C and D out of that? And is it okay if the declaration, if you have a separate declaration in those circumstances, is it okay if the declaration is signed at a later time?
I think it's okay.
Yeah, I think so.
I think it's okay.
So this is Lori Ann. I think that's a policy call for y'all to make, but if the declarations are not signed contemporaneously, do we still want to have the date and the time of the execution, because those may not match up if they're not filling them out at the same time?
Yeah, if we agree that C and D don't have to happen at the same time as the execution and witnessing, then let's talk about that in 3. I'm not hearing a lot of strong support for requiring the declaration to occur at the moment, the same time as the execution and witnessing, because John is right. You can sign a declaration or an affidavit of attesting witness to a will after the fact, as long as we have the declaration itself. So let's. I think we've got that. So C and D can occur at a later time. And then let's talk about in 3 what the declaration says and what we need to change to make that work.
This is Judge Cobb. Before we move there, my question is, when we have, under the present system and everyone is physically present, is there going to be, I think Judge Donahue's electronic problems just earlier when we couldn't hear part of what he was saying, is there going to be any kind of certification, acknowledgement that I in fact heard everything, that there weren't some kind of technical difficulties? And I'm thinking not execution that occurs under the auspices of an attorney who's making sure everything's done correctly, but some individual who has set this up, and is the witness going to say, I in fact heard everything, or
cutting out, I had to dial back in and hear some other things?
Well, they are certifying that they were in the electronic presence, and we've defined electronic presence to mean same as if they were in real time together. So I think in that case, if you've got somebody who was cutting out or you know, not could not be heard or seen or in some other way perceived the same as in real time, then you'd have a faulty declaration.
But how is the witness supposed to know that that was a faulty declaration?
Well,
who's going to tell him that?
Yeah, one way we could do that would be to include in the declaration, you know, the definition of electronic presence. So the witness signing that actually sees what they are attesting that they have, what has occurred.
Because now if we're separating it out and these declarations can in fact be 2 weeks later or a month later or whatever it is, to me we're going very far afield from the you're present, you're actually factually present in the room. You can see me, you can hear me. And now with the electronic additions, having any assurance that something, and God knows technical problems never happen, but there was a technical issue, it seems to me there needs to be a clarification. And again, this is not for attorneys. These are for all the other people who are going to say this is a great way to execute something, and how is anyone going to know that it was done appropriately? If you're cutting out and you're saying something and I can't hear you, do I really know that I've missed something? I don't know.
Yeah. Lorianne, would it be feasible in this statutory declaration form to include below the signature, you know, a definition of electronic presence, so that that declaration that they're signing tells them what they mean by electronic presence?
Yeah, and I think that the samples of the forms that I think it was Lane circulated did have that definition dropped in here. So I could put that in. The reason it got left out, to be frank, is because this requires a certain kind of programming in our software, and our person that does that was out of the office last week. So it was beyond my capabilities to do that. But I think what we could do is similar to how the advanced directive form is set up with the bullet points. We could have it as a bullet point for what electronic presence is, but that also begs the question of whether a lay person is going to interpret electronic presence correctly for what you're trying to get at.
Well, and I guess I would say that we're going to have a better shot at that if the form includes language that tells them what electronic presence means.
Okay.
Because you're right, Judge Cobb, electronic presence. I'm a layperson. I'm a lawyer. I don't necessarily know what that means, but we have a specific definition, and it is specific as to just the same as if they were together. Yeah, Lorianne, if we could do that, I think that would be helpful, so that especially the lay person signing this understands what they're saying that they experienced.
Well, this is Jennifer.
Jennifer first, and then John.
And maybe I'm being too paranoid, but you know, the declaration says I have signed the foregoing document. That conceivably could be a separate piece of paper that is just attached to any old document anyone wants witnessed. And I would be way more comfortable if these declarations were signed contemporaneously with the execution and witnessing.
If you look at the remote, that first one is the declaration of the person signing the document. They're not the witness. If you go down to sub B, that's the witness's attestation, and that's where it has the language, the document to which this declaration is attached, and of which or maybe it should be or of which it is a part, so that there is a connection between the declaration and the document. I think it's probably, I don't think we need that probably for the person executing it.
Sorry, again, couldn't you just have that declaration statement? That presumes then that that person is signing that declaration when they actually have the signed document in their presence? Is that
The first one is the person who is signing the document. So yeah, they're gonna have the documents in their presence.
okay? So then what that means is that the declaration for the witness would never be able to be on the same day because they would have to see the document as it was signed.
What is it? Let's get to that in a minute. Let's look at the first declaration, which is the person executing it. Okay, so this is the person signing the advance directive or the testator. I have signed. Where they signed, date and time, in electronic presence of and I guess we might need to accommodate up to 2 witnesses because the advance directive form, it requires 2 witnesses. But just as far as the person signing the document, is that satisfactory? We got issues maybe with the witness's declaration, but this is the person signing. Is that adequate? I think it is.
Lane, just on. Lane, can I jump in?
Yeah.
You know, the declarations, both of them are just declarations that people are giving as to what the situation was at the time that they did something.
Right.
So when the testator is signing this declaration and saying that this was all honky-dory at the time, I don't see any reason why the witnesses have to be present when the testator does that. So it can be, you can hang up and then you can sign these documents. I don't think you have to wait 100 years to sign them. But I think Judge Cobb makes some good points, and I think her comments could be handled by adding to the declaration that the witnesses were in my electronic presence when I signed the will and asked them to witness it, and they did.
Yeah.
And similar language in the witness's declaration. So I think she's right. You know, they're just saying we were in electronic presence on that day doesn't cut the mustard.
Well, you know,
we were in.
What if we just eliminate, take out have? There, you're in both cases. You know, you can do it. You can do it simultaneously, or you can do that after. What do we think about that?
Just taking out the word have.
Yeah.
Yeah. Not necessary.
So this is Judge Cobb. The downside, what is the downside of having everyone do this simultaneously?
Okay, someone answer that. Ken?
Well, I think it's an unnecessary requirement.
I mean, I had a printing problem the other day, so I printed something out and, you know, like half an hour later, but didn't actually do it while we were on the call. So, I mean, sometimes you have that kind of stuff happening and it creates another.
Again, this is Judge Cobb. Again, this is the formalities. What we're stepping away from is having everyone standing in the room with the witnesses there signing it. And it seems to me that the witnesses, if you're not doing it simultaneously, then you're having to remember which date it was and what you signed in this declaration, as opposed to having it there in front of you at the time. And I guess I'm not persuaded by a printing problem, because print it out ahead of time, have it in front of you when we have these are formalities and these are there for a reason. So we're stepping aside from the actual physical presence And it seems to me we're kind of far afield, waving all kinds of things, saying, oh, well, I can't get my printer to work. Well, then maybe you need to delay executing this.
Well, let's go back up to sub 2 though, because look what we've done. It's in sub 2. You have 2 things have to happen. The witness has to be physically present, and the witness has to be in the electronic presence of the person when the person executes or acknowledges. And I think we agreed that the second part, the witness attests to the person's execution. So the witnessing has to occur simultaneously. It's the declaration we're talking about here that may be separate from the witnessing, that can be executed after the fact. The witnessing does have to occur simultaneously to the execution or acknowledgement.
So why not have it signed at the same time?
Well, you don't have
Then
to
you
have
know
the,
that the witness, you know that the witness remembers exactly what happened because I saw you sign it and now I'm signing this. And so there's no question about my recall of something 3 weeks later.
John?
well, there's no requirement that the self-proving affidavit be signed at the same time. And to me, these are really no different than that.
Yeah.
The other thing is I am frustrated by the printing problem, more so a drafting error. If you get something goofy, like you drop a line in the declaration, and after it comes back, you find out that you had some sort of a typo problem in the declaration, you would have to go back and redo the entire will signing just because you'd have to get the declaration done in the presence of the testator at the same time and all this stuff. And it's not a luxury, you know. We've got people that are doing things on their deathbeds. It's not something that you can plan for and get everything perfect and make sure that all the T's are crossed and have no typos and then schedule a signing. A lot of times, especially with a remote attestation situation, you're often going to wind up in emergency situations where you got a client 6 minutes away from dead and you got to get a will signed.
Yeah, it seems to me, again, there are two different things happening here. One is the witnessing itself, which has to be done in the electronic presence and when the person executes the writing. And the declaration is really just a confirmation of the circumstances under which the witnessing occurred. And I'm sort of inclined to think, and I saw other heads nodding on the screen, that it should be okay for that declaration to be signed after the fact. And so we need to adjust the declaration language. But Judge Cobb, the witnessing must occur at the same time. That, just like we have in the wills requirement, that part has to happen simultaneously. But the declaration is that statement that affirms to the court or to the hospital or to anybody who's being asked to rely on this document that it was properly executed by an electronic means.
This is Judge Burton. Could I ask a couple questions?
Sure.
So, are we contemplating that there is actually going to be a physical document with a wet ink signature to which these declarations are going to be attached?
That is my understanding. That this is not an electronic document bill.
Right.
So then my other question is, and I guess this is primarily to the declaration of the witness, how can anybody say under penalty of perjury that I know that what I witnessed this person sign is the document to which my declaration is being attached? Even if you are on audio and video and somebody says, look, I'm signing my will, you're not actually going to be reading the document that they're signing, and you're not necessarily in control of what document your attestation is being attached to. So I don't see how anybody can truthfully execute that remote attestation declaration.
Well, this is Jennifer, and I agree with that.
This is what.
This is Kathy.
I'm curious. Sorry, go ahead.
Who is that?
This is Kathy, and I was just going to say that in New York, they've adopted a 6-step process for signing, and part of that is as one person signs, then they have to scan it and send it to the next person who signs, and then it circulates by scanning around without breaking the connection. So, I mean, it's complicated, but it's a way of getting things done.
And to clarify, that means that everybody stays on the connection as the scanning and emailing is done, so that there's a unbroken real-time presence while everybody signs the same thing.
But that then also presupposes that you have a scanner or a printer in a hospital or
a cell phone,
which limits, you know, especially people who might not have the economic means to have all the current technological bells and whistles. It might be putting a burden on those where their testamentary wishes are not going to be heard.
And Judge Burton, let me ask, you know, we have the circumstance where the attestation, witness's attestation to a will is signed sometimes years after the will was signed. But we accept the fact, we accept that attestation, even though it is going to be attached to a will that was executed, you know, say years ago, that they didn't read.
Well, so are you talking about the affidavit of attesting witness, or are you talking about the actual witnessing of the will?
Okay.
Because I don't think somebody can actually witness the will years later. They can sign an affidavit of attesting witness later, but then they're attesting on that day, I was there in this person's presence when they signed the will. And so that goes more to John's issue about why does the declaration have to be done at the same time?
Yeah, and I agree that the witnessing should happen at the same time.
Right, but again, my issue is I do not see how anybody could truthfully execute that declaration of remote attestation when you have no way of knowing what the person was actually signing, and you have no way of knowing what your attestation is going to be attached to.
This is Jennifer, and this really sort of goes to what's on the next page about the documents that can be executed by remote attestation. And I still feel, as I did last week, that wills should not be remotely attested under this statute or whatever it is. And instead, we just use the harmless error process. That's my view.
I agree with that completely. This is Judge Burton.
And this is Judge Cobb. I think that was my position last week as well.
All right, let's stop and have that conversation. That would leave wills then really, and this is looking at Heather's comment that's on the chat. That would leave then the harmless, we call it harmless error, but that's really not what it is. But that would leave the harmless error statute to cover those scenarios where the will can't be witnessed in accordance with the formalities.
So this is Judge Burton. Could I say a couple things on my experience with the harmless error statute?
All right, but we're not going to review.
So the harmless error statute basically requires, you know, some information supporting why this is legit and then notice of time to object. I have not yet had one of those that has had to go to a hearing. And if one of those does have to go to a hearing, you know, then that means that there's some question about the legitimacy of that document, and the court gets to do what we're designed to do, which is hear evidence and make a decision based on that evidence. I don't think that is an undue hardship. I think if you're going to loosen up the formalities that have traditionally existed with a will, it's not an undue hardship to have you go through the harmless error process. And I'm not seeing that people's last wishes are not being honored. All I'm seeing is that there's an opportunity for somebody to say, let's pipe up if we think this is not kosher.
Let's talk about that. I want to hear from somebody about whether wills should be excluded from this statute, which relegates them to the harmless error process.
Well, this is
This is
John. Let me chime
Lorianne.
in.
Lorianne, go ahead.
I have a quick comment to tag on to that can be addressed in the discussion. Is if we specifically exclude wills, so we drop wills down to subsection 5B, as this doesn't apply to wills, will that exclude them then from the being interpreted under the harmless error doctrine under 112238? Will that we're saying expressly that we don't want them to have this ability, that will the judges, and this might be for Judges Cobb and Burton to answer, would you interpret that the specific exclusion to indicate that in a hearing to determine if it was the execution works, would you look at this and say, well, the legislature specifically said that they didn't want wills to have this option for remote attestation, so we're not going to extend it?
Lorianne, it's a good question, and I think if we were to eliminate wills from this statute, we would need to make sure that we do so in such a way that we don't exclude the harmless error statute from possibly applying in these circumstances.
Yeah, this is Judge Burton. I think you could always add something that says, this is not intended to, reduce the application of 112-238 to a will executed in any way whatsoever.
All right, I want to hear some passionate argument about this. Do wills come out of this?
This is John.
Give us some passion, John.
I'm not quite understanding this. If you're going to rely on harmless error, then you're going to have wills with no witnesses.
Right, you may.
That's the logic. If you can't, if you had the physical presence possible, then you wouldn't be messing around with remote attestation at all. It's not something that you're going to do out of laziness. You're using this because you don't have a better alternative. So I would think everybody would be better off with a remotely attested will than they would be with a will with no witnesses and a harmless error argument. And I appreciate that most of the harmless error cases have not been contested, but there is a Court of Appeals opinion that came in a hotly contested harmless error case. And it's not that people have legitimate quibbles about the mode of execution. The contest comes because people don't like the content of the will. They're not getting enough and they want more. So they throw the will out, they get more under intestacy. I don't think it's really a good idea to force people to rely on harmless error and have unwitnessed wills and assume that they're going to get probated.
Let me try this. I feel like Henry Clay, the great compromiser. What if we were to say that a will executed under this statute would be routed through the harmless error process to be proved as a will? It would allow execution of wills by remote attestation, and we know that the great majority of wills that are submitted under the harmless error statute don't get contested, but it would add just one level of protection in the case of wills, which we want to be protective of, to say that a will executed under this bill has to be proved in the same manner as harmless error, as the harmless error, with even a cross reference to the statute. Judge Burton, does that satisfy your concern if it were to apply to wills under these circumstances?
Well, I think that satisfies my concern as to wills, in that, then you're back into harmless error. Right. I still have the concern about any attestation that I've already said, which is I simply do not see how the witness can truthfully execute that declaration for any document.
And this is Judge Cobb. There's nothing in this that says you have no alternative but to have it electronically witnessed. That may be the first choice that somebody has, and there's witnesses that are ready, willing, and able to be actually physically present instead of electronically present. And I think that a lot of times, while Mr. Dranius's point is well taken, that people contest wills because they're greedy and they want more, that Court of Appeals case was, there was a real question about what was executed, why, all of those different things. So, I'm still concerned about rerouting wills through the harmless error statute, but I think Judge Burton's point is well taken, is how do you ask a witness to make this declaration when they don't know what in a cat hair was even signed there?
This is Judge Donahue. Can you all hear me now?
Yes, sure. Yes, we can, Judge.
Okay, sorry about the phone ringing there. I looked at the attestation, and I can see Judge Burton's concern, because essentially at this point, it's saying that the document that it's attached to was signed on a date and time. And so the person making the attestation, I agree with Judge Burton, really can't, under penalty of perjury, say that this is the document. So maybe we could modify the remote attestation declaration to be more of something that the witness is attesting to, is that on such and such a date and such a time, I was electronically present when, fill in the name of the person declaring it, signed a document represented to me by that person to be their will. And so I think that would, rather than proving the document, it would essentially just certify that the person making the attestation attested to what the person told them they were signing at a date and time, and that they were electronically present when that occurred.
This is Judge Cobb. So then it wouldn't be self-proving as far as a will?
Well, I don't think that we were ever looking at these as making wills self-proving. I think all we were doing with these declarations were essentially confirming that the requirements of electronically signing the document were met.
Right.
So this wouldn't be self-proving.
So this is Judge Burton. I think that would be a more truthful attestation that somebody could make, but it doesn't go very far in terms of authenticating the document. You certainly couldn't authenticate a document in court. Somebody hands you a will, you can't say, well, I was present in a room when this person told me they were signing their will, and I don't know what they actually signed and whether this is what they actually signed.
We had this conversation last week, and it does raise that issue. And I think we can solve that with wills if we require that will executed or witnessed under this bill be filed under the harmless error statute. As for other documents, it is true. What we talked about last time was requiring that each of the witnesses have a complete copy of the document when the execution and the witnessing occur. And we could do that. That does raise issues about privacy. Sometimes you're asking witnesses to witness a document, but you don't necessarily want them to know what's in it. And if we require that everybody have the complete document, then we're creating a hurdle there that that implicates privacy issues. But I think does open the door to the question that Judge Burton has raised. Then how do we know that was actually for sure, beyond a shadow of a doubt, the same document that is that the person signed? I don't know. I think we decided last time that the policy of making this a possible way of getting these things signed conveniently outweighed the risk of fraud in execution of advance directive or something like that. But I mean, it's a real issue, and I don't think we can say that it's not. Melissa did offer to comment there on the chat. Video conferencing services allow screen sharing. I guess that again raises the privacy issue.
Lane, this is John. Can I chime in?
Yeah. Yes, John.
I think that just comes with the territory. You know, if the point's a good one, how do you know what document the witness witnessed? You know, when you do this with an in-person execution, the witness doesn't need to do anything because the testator and with the witness's signature on the same document. So the only way you can verify that they both signed the same document is for each of them to have a complete document, and then you can compare them and see if they're the same document. So
or you take what Chris described as the New York approach, and you scan the signature pages around so everyone, you know.
Anyway, they're kind of signing the same document.
Yeah,
Yeah. So
I
similar
appreciate that I'm
thing.
being blamed for Kathy's idea.
What's that?
That I appreciate that I'm getting blamed for Kathy's idea.
Oh, okay. Was that Kathy's?
This is Judge Burton. I'd be curious to at least see what that New York statute looks like.
Okay. And certainly we can.
Yeah, Kathy, I think you mentioned it. If you have a copy, if you could send that to me, I'll distribute it out.
Yeah, I do. I was participating in an elder council CLE, and they provided some information on that, so I'll just send it to you.
Well, let's talk about that in concept then before we go further. Some sort of function where that requires the scanning of the document so that we have signatures. Some will be original, but some will be scanned, but all on the same document. I understand the protection that affords. It guarantees the reality of the document being the same that's signed as witnessed, but it does then create a functional issue of people that can't scan, and we limit the utility of this, I guess, and that's the trade-off. What do we think about that trade-off? Certainty versus utility.
I think you have to throw the privacy concern in too. I mean, if you're scanning the whole document and sending it around to a bunch of people, seems to me you're creating some privacy.
I'll bet you could scan just the signature page. Just like when you sign a will. I'm going to guess you could probably do that on the signature, because at least then we know that the signatures, the person signing it, their signature is on the same page as the witness's signature, and it was all done during the electronic presence. What do we think, folks? This is, I think, kind of a crucial policy choice.
Well, this is Jennifer, and it seems to me the simplest thing would be to just, on the video, assuming everybody has the ability to see, you just show that the signing person, holds it up to the camera, and here's my signature, here's the date. They could even write in the time, and then at that point, everyone can attest that they saw that signature. That avoids the privacy issues. That avoids people not having scanners.
Right. Well, that's kind of what we have, because the declaration refers to a date and time.
And this is Judge Donahue. I think the declaration could include also just what was just said, which is I was shown the signature page and confirmed that the individual had signed it by remote means, and that could be included in the declaration as well, I would assume.
Yeah. And you still don't know what your declaration is being attached to.
I agree, but I think the declaration at that point would be not so much attesting to a document as to attesting that the process occurred consistent with what's required to have a remote a remote signature. So yes, it would not be attesting to the document. But again, even I think under that New York statute, if the signature page gets passed around to all 6 people, they all sign it. The person can then take that signature page and attach it to any document that they want. So I don't think there's any hard and fast confirmation on that.
And the same is true. Let's go back to the advanced directive. That's one we probably see a lot of. You know, sure, the witness signs on the document, but they don't know that after they all left the room, those signature pages were switched out and attached to a different document. So I'm not sure that this, if we do something like what Judge Donahue or whoever it was has proposed, you know, some sort of, you know, assurance in the electronic presence that you're watching the person sign and you are signing, you know, at least that same page as the person signing. I don't think we're authorizing anything that couldn't happen to a document signed in physical presence.
Right.
Exactly. You could switch the signature page of an in-person sign.
Yeah.
You know, the New York procedure is, you know, you're getting a will signed in 3 counterparts because everybody's it's not one piece of paper. You got 3 pieces of paper. The testator signs one, scans it to witness 1, witness 1 prints it, signs it, and then scans it to witness 2. So each of the witnesses and the testator each have a piece of paper with their signature on it. So you got to accumulate all those to have a complete will. So it's just a way of signing in counterparts without having everybody holding on to the entire document. That's all.
Yeah, I mean,
It's
Judge
fine.
Burton, do you agree that, I mean, to the extent that a witness, the page that has a witness signature where the document was witnessed in physical presence can still be, at some point, attached to a different document?
Yeah, I mean, there's always ways to commit fraud, but why do we want to make it easier, I guess, because if you're saying, let's say we're talking about a advanced directive, so the person executing it signs it, and then the witnesses sign right below there. Yes, you can take that whole piece of paper and attach it to something else. But to me, that's different than I'm just signing a declaration that I don't know what it's being attached to. At least in the first one, I knew at the time that I signed it that it was part of the same document. It just seems to me like you're just making fraud way easier.
This is Judge Cobb, and I think I want to second Judge Burton's concerns that you have a document with 3 actual ink signatures on a page. And if the witness is questioned, I think they can say, yes, it was passed directly over to me, kind of thing. This is you're removing all of that assurance that a witness has.
Well, maybe, I'm not sure that you are, because then if the question is, and is that the same document that you witnessed? Is this document the document that you witnessed? You would have to say, I don't know. I didn't read the document that I witnessed. I just saw it signed and I signed my signature too.
Right, but you did at least know that you were signing the same piece of paper that the person executing it signed.
You were signing.
You did at least know that.
You were signing a page of a multiple page document that you don't know what the contents were.
Well, this is Jennifer, and the process works differently when you have a lawyer, and the lawyer after the signing makes the file copies, and there's a proof that here's the document that everyone signed. Whereas with this other process, you don't have that same protection.
Oh, right, and that is what is so important, and what I feel like a lot of the practitioners who are on this committee don't see. I know that you guys you're going to do it all right, and you're going to make sure that it is the same document, and you're going to have a record, you're going to do it all right. But we see all the stuff that people go out and do when you don't see them. And that's a whole other ball of wax.
Lane, can I chime in for a second?
Who's that?
This is Jeff from Multnomah County.
Oh, Jeff. Hey, yeah, sure.
Just to piggyback on the last comment, as a practical issue, is this something that gets written out as to explicit steps that someone is supposed to follow to make this legitimate? Because in practice, I think the attorneys most likely to rely on a shortcut like this are not going to follow the letter of the instruction. So what the courts will see, at least people like me who get the first eyes on a lot of these, are going to be pretty ambiguous, unclear attempts to make this work.
All right.
Does that make sense?
Are we going to make it or not? Yeah, and Judge Burton, I guess what I would say too, and this in the spirit of spirited conversation, you see the 2 or 3% of the bad cases. You don't see the 95, 96% where a process, is used and accomplishes, a desired end, and provides convenience to, somebody who needs to have a document signed and witnessed, and everything is fine and it goes through and there's no challenge. So, I mean, obviously all of this is subject to fraud, but, I think the practitioner's experience is that the vast majority of these things, of course, work, and they serve a positive public purpose.
Yeah, I would say I don't know that any of us know what the percentages are. I mean, you're right. I don't see the stuff that you guys do that works and flies and you never have to come to court. And that's great. And I know that stuff is out there. I'm just also saying you guys don't see the stuff that we see that gets filed and done by the people that didn't come to your office. And I don't know what, I couldn't tell you what the percentages of each are.
Yeah.
Well, and this is Judge Cobb, and the fact that, back to Judge Burton's point, is we are making it easier for people to avoid going to an attorney's office and electronically executing something that is fraudulent or, erroneous or whatever it is. This is making it easier. And there's nothing that I've read in there that said, you have to try and do this in person. This is just an option that's going to be out there. And I don't think convenience is necessarily a necessity. I would say yes. Convenience, does that outweigh the potential for fraud that's out there? And I don't think we can just limit it that these are not just limited to what occurs in attorneys' offices.
Yeah, this is just Judge Burton. For one, I think I'd probably be very comfortable accepting any of these documents that's also accompanied by a declaration of an attorney who says, I know this is my client. I know I prepared this document. I know this is the document that my client signed. I know who the witnesses are. Great. Yeah.
Okay. Let's talk about that then, because I'm sitting here picturing myself in front of the Senate Judiciary Committee with Judge Cobb and Judge Burton at the table next to me, and it's not a pretty sight, and not what the legislature wants to deal with in a special session. So let's talk about that work group. Do we want to include a requirement that a document that is witnessed as we've set out in this statute must also then be accompanied by the declaration of a lawyer? We kind of touched on that. Thank you, Chana. we kind of touched on that last time, and we didn't stick there, but it sounds to me like we're back there as maybe a practical necessity of getting a product that has a chance of moving forward. So members of the group, what do we think about that? An attorney's declaration.
If we require an attorney's declaration, we're just being jerks and making money for ourselves.
Well,
that is not. I don't see that flying, especially in front of many of the legislators that I've testified in front of recently.
I did share, I think, to Sandy and Susan in an email. I was the victim of a bill in maybe 1999 or so, I think. We introduced a bill to that would have given lawyer legislators CLE credit for their time in the legislature. And I remember the debate on the House floor. It got so bad that I even voted against it, and I carried the bill. And it failed 0 to 60. Lawyers doing favors for lawyers bill. So I appreciate your concern there, John.
I, for one, would be totally happy to rely on the Judge Burton made us do it defense. I think it's just fine. And she's right, and Judge Cobb as well, that, when you got people doing this on their own and they're not necessarily the most honest people in the state, there's a lot of potential for weird things to happen, and focusing on lawyers controlling the process when you've got something that's this sensitive, I think that's supportable. Doesn't bother me one bit.
For those of you who I can see on the screen, kind of thumbs up or thumbs down for at least pursuing an attorney's declaration. It looks pretty.
Thumbs up from the trial lawyer.
Huh?
Thumbs up from the trial lawyer. Like
thumbs up from the trial lawyer. So I mean, but now it is a question of, I think, of go or no go. If we don't have that, I think this is probably a dead effort because, again, without a strong, solid consensus coming to the legislature saying, yeah, this is a good bill and we need it, especially in a special session, there's just no point. And so
there is another idea.
What?
There is another idea, and that's just having this just apply only for the duration of the pandemic problem.
I'm not sure that satisfies the judge's concerns. Judges?
This is Judge Cobb, that these wills can last for 20 or 30 years. And even during the pandemic, I think we've all read and seen all the fraudulent things that are out there that wrongdoers are going to jump on as quickly as they possibly can. And, making this an, Attorneys Full Employment Act, the alternative is just do it in person the way that wills are traditionally done. And if you want to do it that way, you don't have to have the attorney certification on it.
Right.
Which then makes it see your attorney or die?
No.
Now remember, let's on wills, let's say we've agreed that those are going to have to be presented through the harmless error statute. So let's think about other documents that don't have that kind of protection, like advance directives or consent for autopsy or request for medication, those kinds of things. Because wills, I think if we're agreed that a will executed under this bill would have to be offered through the harmless error statute, then I think we've kind of covered the concern for wills, and we're talking about these other documents.
Well, this is Jennifer, and then in that case, as long as I can see the page that the signing person has signed, that's all we need. And I'm fine with all those other things being, I don't have the same concerns about wills. I'm fine with all those other things being remotely attested.
All right. Let me hear from the judges the same thing.
So this is Judge Burton. Just looking at that list, I think the other one that I would be particularly concerned about besides wills would be the advance directive. I'd be a little worried about that. I guess I'm not as worried about consent for an autopsy or disposition of remains or anatomical gifts.
Okay.
This is Lori Ann. What about the request? What about the request for medication? That's under the physician's assistance with
Death with dignity.
Yeah, I was trying to think of the PC term for that, but yes, that's death with dignity. Do you want it to be able to be remotely attested because of what that is? The political, that's a policy decision that I think should be expressly made.
Okay, thanks. I had not looked up all of those. Request for medication doesn't really stand out as being death with dignity, but thanks for pointing that out.
Lane, this is Kathy.
Yeah.
So I'm also looking at the acknowledgement of paternity. I mean, there's a couple things here. I just feel like we don't know enough about these things to know where the pitfalls are. Makes me a little uncomfortable that we're deciding for these other practice areas.
Yeah.
And this is Gretchen. I think that'd be my big concern. We don't know why the legislature chose to require attestation in these particular cases as opposed to like contracts where electronic signatures are allowed. So what is it that is required for each one of those and why they wanted that? What the purpose is. And some of them, it may be that it isn't valid purpose anymore, or it can be, the concerns can be addressed. But I just think that we don't know enough about what these other ones are to be able to go to the legislature with it.
So let me ask this then, still trying to find a way through the thicket. I'm going to say that I think this proposal is probably a non-starter for a special session. Among the work group, do you have interest in looking at the New York process and incorporating that, the execution methodology in our bill? It reduces the utility of it because it's only going to be available to people who have scanners and printers. But the benefit of that is that it probably enhances security and reduces the risk of fraud because signatures are all going to be at least either wet ink or by scan on the same page of a document, which replicates what we do now, where that's really all you're witnessing anyway, is you saw them sign their signature on this page of that document. You didn't read the document. Do we have enough interest in moving forward with this, to at least examine the New York approach and see if we can come back with a draft that incorporates that? That was an ambivalent shrug, Ken.
I'm not sure it's worth the trouble.
Okay.
I kind of agree. If we're not going to get this into a special session, then why are we?
Oh, no.
even-
I'm saying special session, but with the New York process, with the scanning and printing and signing. Still, if we could get consensus on that, then I think this would be a potential process, project for special session.
For the sake of my estate planning clients who are both terrified to leave their houses and horribly anxious to get their estate plans done, I think we owe it to them to keep looking at something to try to make this move forward.
All right. I'm willing to. I think.
Sorry, and I, we just spent 2 hours, and we spent a bunch of time last week. I don't have clients who have scanners, who can, much less who can even print things. And yesterday or last week, I had a will signed by a woman in lockdown, at a nursing home with no witnesses, and her, you know, her son took the will to her, dropped it off, picked it back up. I have it in my possession, and I went over it with her. And so there are ways to do this without having to have a witness. And I personally don't want to spend time trying to wade through this other statute that's still going to have this issue of, do we even know that the document that has the signatures on it is the same document that the person signed?
Okay, here's what I want to
That
do with the last.
solution does nothing for advanced directives. It does nothing for things that are not wills.
Right. In the last 5 minutes that we have, we're going to do something very unusual, and I'm going to ask for a roll call on this, and I'll ask for everybody that's on the call, because I think I want to be conscious of the sentiments, because we'll hear those sentiments in the legislature even if we don't listen to them now. So Sandy, would you go down the attendance list here? And
yeah,
really this question is not do you support it, but do you want to see a draft that incorporates the New York approach to execution?
So Lane, just to be clear, it's going to be a bit, I'll do the roll call for all the names that I have. There's a bunch of phone numbers who I'm not entirely sure who they are. So I'll call all the names that I have, and then I might have to list individual phone numbers afterward.
Yeah, so everyone make sure you know the last 4 digits of your phone, because Sandy can call you by the last 4 digits.
Lane, this is Jennifer. One other quick suggestion. We could use the process we've worked on today for the advanced directive. I agree, there does need to be a way of doing the advanced directive, and that form is only 6 pages long. So you could actually have each page be showed.
Yes, Linda, could I call you back? I'm in the middle of a conference call.
Yeah, but Jennifer, you could, but that's the privacy issue. You're making some pretty personal choices in that advanced directive. Do you want, a witness to see those?
Well, I agree that there is that problem.
So I think I'm interested in whether the committee, the work group would support looking at a draft that incorporates the New York model, or do we just say, good effort, we didn't get there? So a yes would be to say, next time we meet, let's ask Lorianne to graft the New York statute onto our effort. A no vote would be basically, I think, end of the road. So Sandy, take us down.
Yeah, so I'm just gonna call you up by name, and once I exhaust the names, I'm gonna go through phone numbers. So This is the people I know who are on the call.
Kathy, are you gonna keep count too?
I'm sorry? Yes, I'll keep count. Okay. So Kathy Belcher. Yes. Lane.
I would say yes.
You go last. Yes. Okay.
Oh, I'll say yes.
1 second. All right. Eric Weiland.
Yes.
Is Eric there?
Yes.
Thank you. Susan Gary.
Yes.
Christopher Hamilton.
Yes.
John Dranas.
Yes, and I think it should be an alternative. They could do it either way.
Ken Sherman.
No.
Linda Thomas Bush.
No.
Amy Zubko. I don't know if you vote, actually.
Yeah, let's not put Amy on.
All right, that's fine.
This is
Gretchen,
Amy. I don't vote. Thank you.
I understand. No problem. Gretchen Merrill.
Yes.
Brooks Cooper.
Yes.
Mark Comstock.
Yes.
Jennifer Todd.
No.
Sarah Kearsley.
Yes.
Melissa May.
Yes.
Thank you. Heather Gilmore.
No.
Okay. Judge Donahue.
Yes.
Judge Burton.
Yes.
Judge, sorry, we gotta make sure. Judge Cobb.
Yes.
Brian Marsh.
Yes.
Okay. Now I'm going to start doing phone number. Oh, Matt Shrimp.
Matt Shrimp, yes.
Yeah. Okay.
Then we got Jeff Petty too.
Yeah, Jeff Petty.
No.
Okay. And then make sure I have all the Brooks Cooper. Oh, Brooks, I got you. All right, now phone numbers. Chan, I know you're just listening. So let's start with 503-353. Oh, sorry. 503. So last 4 digits. Let's do it that way. 0749.
Rick Mills on behalf of DHS. I abstain.
Okay. We'll do 6079. All right, we'll come back to you. We'll try 3547.
Hi, this is Judge Whipper. Do I vote?
You're welcome.
You can.
I would say yes. I'd like to see the draft.
Okay. We'll go 9574.
This is Shannon Conley. I vote yes.
Okay. 6657.
This is Amy Billiou. I say yes. I agree with John. I'd like to see it as an option or an alternative.
All right. Is there anybody who I haven't named?
This is Cleve Abbey. You called my number, but I was on mute, and my vote is no.
Okay.
Okay, so what's our count?
So hold on. We have, I was trying to figure out who there were. I got 1, 2.
I think there's a majority.
Yeah, it's a strong majority for yes. I have 7 no's. All the rest are yes. That's over 20.
Okay, so Lorianne, I did not let you vote because I didn't want you to try to influence your workload. Let's do it. We'll take a look at this. We'll see if we can learn to love it. We'll take one more stab. I think it'll be one shot to see if we can get the something like the New York model to a place that we could support it here. And that takes us to almost 11:59 on my computer. Thank you, everybody. This is hard work, but I appreciate you sticking with us. We'll take another run at it, and the e-wills will go on the next agenda as well. But
so really,
yeah.
Yeah, just on scheduling. Yesterday, I sent out a scheduling link with the next 2 Thursdays. If you could, were able to respond to that link of which one of the next 2 Thursdays work better for the majority of the group by tomorrow. I'd like to get that scheduled. I appreciate that, and then I'll work with Lorianne to get the new draft out there before the meeting.
And what I saw in the paper this morning is that the special session might occur after May 20th. So. It's still a might, and it's still a month away. So we've got some time. Thank you, everybody. Good to see you all. Stay well, and we'll catch you next time.
Thank you.
Meeting adjourned.
Thank you.